Welcome to Sports Wise, a podcast about sports and the law with your host, me, Gabe Feldman, director of the Tulane Sports Law Program and co-director of the Tulane Center for Sport. On this episode, I'm joined by a living legal legend, David Boies. David is truly a man who needs a little introduction, but I will mention three of his most famous cases: U.S. versus Microsoft, Bush v. Gore, and Hollingsworth versus Perry, the marriage equality case. But David joins me to talk about his work in the sports world, including his current representation of Panini in its antitrust case against Fanatics, legal issues that might arise when pro or college athletes agree to pool their NIL rights and negotiate deals with video games and apparel companies, his thoughts on the legal challenges facing college sports, and much, much more. Here we go. Before I get started with the interview, I want to make a quick but very exciting announcement. The Tulane Summer Sports Institute is launching this May with an immersive 2-week course titled Running a Professional Sports Franchise, where you'll learn directly from front office executives in all of the major professional sports leagues and me. This course is open to any current undergraduate students at any school. For more information, please visit tulane.edu/sports institute. That's tulane.edu/sports institute. Now on to the interview. Welcome to the podcast, David Boies. Thank you so much for coming on.
Thank you.
All right, here's my first question. What do you prefer to be referred to as? Legendary, Titan, 100 most influential people in the world? What's your favorite superlative?
Grandfather.
Grandfather. Okay. All right. Fair enough. And here's my other question. When you were named one of the 100 most influential people in the world in 2010, were you all upset that you did not get named in 2011?
Well, I think they just name you once.
Oh, okay. So that's how you make yourself feel better, that you only get.
I think it's one and done.
One and done. All right. Fair enough. Okay. So you have been involved in some of the biggest cases in the country. You are widely known as one of the, if not the top litigator in the country. I had the pleasure of working briefly back in my old private practice days with Brendan Sullivan and David Kendall and Greg Craig and some great litigators. And I've gotten to see you in action from my time during the NFL Network. And I want to talk about the NFL case you were involved in back in the day.
Yeah.
But this is not the podcast where we're going to talk about your defense of marriage equality or Bush versus Gore or Westmoreland or Microsoft or any of the many, many, many incredible cases you've worked on. We're here because this is a sports law podcast to talk about some of your sports law work. And I want to start with the case that you're currently involved in, which is, I think, flying a little bit under the radar, maybe just because there's so much going on in the world that it's hard to pay attention to everything. But can you talk a little bit about the Panini versus Fanatics case and the general claim here? Because this is a potentially massive case, not only in terms of financial liability, but just in terms of the future of collectibles, and Fanatics really control over a lot of the sports collectibles apparel industry.
I think that's right. And it also really has to do with collective bargaining and the role of leagues and players associations. So it is something that can really, I think, affect the future of sports beyond just collectibles. The primary issue, the most direct issue, is the issue of collectibles. And, as you probably know, Fanatics signed up very long-term exclusive dealing arrangements, like 20 years, with all three of the major sports leagues: baseball, football, basketball, and the players associations, which locked out all other competitors for a very long period of time. And Panini's argument is that violates the antitrust laws because the antitrust laws restrict the kinds of exclusive dealing arrangements that can lock out competition. Because the principle of the antitrust laws is that competition is good for consumers. It's good for collectors. It's good for the people who are operating between the collectible manufacturer, Panini or Fanatics, and the collector themselves. It increases prices, restricts the kind of innovation that you've seen over the last 10 years that's come from competition, competition from Panini, but also competition from other suppliers. So I think that the collectibles issue is one that I think people most focus on right now, and the exclusion of competition in this very important area that a lot of people enjoy and a lot of people profit from.
So I want to get into the collective bargaining aspects. You mentioned the role of Players Association in a second, but one of the arguments that you've heard and that have been made against Panini is that this is what happens when somebody wins the competition and Fanatics gets to be the exclusive trading card dealer or trading card partner, much like Panini has been the exclusive trading card partner for other leagues. And this is kind of sour grapes that now that they've lost out, they claim it's illegal, but it's in situations where Panini has won out, others have claimed, well, Panini is engaged in illegal and anti-competitive conduct. So it's obviously not just about who wins the competition if they're winning on the merits. Tell me what Panini's argument is to what Fanatics is doing that's different than what Panini did to gain their dominance when they were dominant.
Well, I think there are several things. First, every time you have an exclusive dealing arrangement, you in effect lock out competitors for some period of time.
Right.
If you lock them out for a year, it's different than locking them out for 20 years. You lock them out for 5 years, it's different than locking out for 20 years. Panini has never had contracts for anything like 20 years of exclusivity. And the duration of the contracts is something that's one of the more important aspects of an antitrust analysis. The second thing is that Panini has never had exclusive dealing arrangements with all three of the major sports leagues. One of the advantages of having different companies producing collectibles for different leagues is that they are, excuse me, they are in a position to quickly compete for future business when the contracts come up. If you lock out everybody for 10 or 20 years from all the major sports leagues, then you've essentially eliminated competition for the long term. You've eliminated competition in duration, and you've limited competition across the whole spectrum of major American sports. So both of those are very important parts of the antitrust laws and very different from what Panini did. In addition, what Panini did is when they entered the market with very short-term contracts and with non-exclusive contracts. And it was only after they had proven themselves, when they had demonstrated their ability to compete on the merits, that they began to get longer-term exclusive dealing arrangements. Here, those arrangements with Fanatics were baked into deals that were not open to competition. There were not competitive bids, for example. So you didn't have the opportunity for real competition on the merits. So I think there are a lot of differences.
Right. And it's interesting when you talk about exclusive deals or long-term contracts, a lot of people hear that and say, well, that's just the way that people do business. And when I teach the United Shoe case to my students,
Right.
and we talk about the anti-competitive conduct was a lease and long-term restrictive leases, it gets to the heart of the question of when is something that appears to be good for one person's business but bad for another person's business is potentially illegal because it is either more restricted than necessary or all the different elements that you're arguing here. So it is interesting because some people, I think a lot of people look at what Fanatics is doing and say, well, they're kind of taking over the sports world, but they're taking it over because they're just outbidding other companies. They are doing a better job at competing, and this is what we want. But obviously your argument is that no, they're doing this to exclude competitors. These changes they're making and these deals they're making are designed to just drive out and exclude competitors rather than to benefit the consumer.
And
Is that a fair summation?
I think that's fair. And remember, the consumers are not at the bargain table here.
Right.
They're doing deals, long-term deals, with the sports leagues and the players associations. But that is something that is not necessarily good for the consumers. What's good for suppliers is always the absence of competition. The more you restrict competition, the better the suppliers do, because competition requires the suppliers to innovate. competition requires suppliers to reduce prices. Competition helps consumers. The lack of competition helps suppliers. And I think what you're seeing here is exclusive dealing arrangements that are not just short term, but are long term, not just
Right.
with a particular league, but with all of the major leagues. And that gives Fanatics power over price, power to limit innovation, power to take advantage of retailers, power to take advantage of collectors. So I think that's the essence of what antitrust law is about.
And so you mentioned price and innovation. What's the claim as to the ultimate harm to consumers if your case doesn't succeed? What do you see as the overall harm to the market?
Well, I think first you see increased prices, and just look at what Fanatics has done in apparel, where it has achieved a dominant position in sports apparel. What you've seen is prices go up, and you've seen quality go down. You've seen a lot of comments from people buying it, and even from the teams in terms of complaining about Fanatics quality. So I think you see a reduction in quality, you see an increase in price, you see an unwillingness to let other people in the supply chain participate, an attempt to squeeze out retailers, to eliminate people who are playing a productive role in between the manufacturer and the collector. So I think you see all of the kind of traditional antitrust problems that you expect to see when you limit competition.
And then, so let's talk about the Players Association and one team, because there is an argument that, and I think this referred to them as pajama cards, where you have the
Right.
right to show the player, but the player can't be in the team uniform because the league owns those marks and they're not going to license them to this other person. But if you can get the players, either the Players Association or even individual players, put them in there in a generic jersey, and people say it looks like a pajama, so these are pajama cards. Tell me why that's not competition, even though it's maybe not the same product, why that's not in the same relevant market, and the role more broadly of the Players Association in these claims.
Sure. I think the pajama cards are a form of competition, but it's a very limited form of competition. What collectors most want are the players in their current uniforms. So I think that even though there is some competition around the fringes, what you see is a preclusion of the most direct competition and the most important competition. I think one of the issues with respect to the Players Association is the extent to which the Players Association, and one team in particular, is really protecting the interests of the individual players, as opposed to the people who manage those organizations. I mean, one of the things that you have seen with the development of one team is that the percentage of the royalties that is going to the players has gone down sharply. You have the managers benefiting, sometimes you have private equity benefiting, but the individual players have not done well. And we had an arbitration with one of the players associations in which the player association had terminated Panini prematurely because they had been asked to do that by Fanatics. And not only did that mean that the players lost out in very substantial amounts of royalties, but they had to pay damages, millions of dollars of damages that really came out of the players' pockets. The players' associations here have not done a good job of protecting the players' interests. They favored the people who are managing it. They favored the private equity people who are participating in it. But the players have gotten a little bit screwed.
And there's been a countersuit where Fanatics sued Panini for trying to block Fanatics from hiring some of Panini's folks, which are part of Panini's lawsuit against Fanatics, and as I understand it, the judge decided to keep those cases separate, and there have been a couple of discovery rulings, I think just maybe a few weeks ago, and we're still waiting on a trial date. What's next what's the next big domino to fall? And I think you were quoted earlier saying that you expect that this case would likely settle. I imagine you would probably say that about every case because most cases are likely to settle. But what do you think is, or what is the next step in this litigation?
I think one of the reasons that you haven't seen a lot of attention paid to the case is that it's now in sort of the quiet period. It's
Right.
not quiet for the lawyers. The lawyers are pretty busy, but it's quiet in terms of any real substantive decisions. We're in discovery, and while discovery is a very important part of the case because you're getting access to your opponent's documents and you're taking your opponent's depositions, and it's very critical part of preparing for a trial. It's not very interesting to the outsider.
Wait a minute. I thought that decision about who gets to be a custodian of the information was fascinating. I can't
Yeah.
believe you don't think that was well, sorry, go on. I
No,
interrupted you.
no, it's the kind of thing that only a trial lawyer can be interested in, and we are very interested in those kind of things.
Yes.
But in terms of what tells a layperson about the case or where the case is heading,
Right.
it's not very explicable.
And so what's the next substantive date on the calendar?
Well, we don't really have a really important substantive date on the calendar. We're working towards summary judgment. We fundamentally won the motion to dismiss. Most of our claims survived. Very limited claims from Fanatics survived. But before we go to trial, we've got the summary judgment stage. And that will be an important time. And that will be a time that I think you will have not only briefings that will help describe to people what the case is about in greater detail, but you'll also have some decisions by the court. The summary judgment stage is sort of the last stage before you get to a trial. And once you're past summary judgment, you're either then going to have a settlement or you're going to have a jury trial.
But there is no trial date set yet, as I understand.
No, we don't have an effective trial date.
Okay. So we'll look for the summary judgment motions and then we'll get some more widespread attention on this if it doesn't settle. Let me shift gears a little bit to, you will certainly not remember this, but we were washing our hands next to each other during one of the American Needle arguments and then during one of the Brady versus NFL arguments. But in the Brady case, the NFL lockout case back in 2010, 2011, when you were representing the NFL, and the issue there was, when does the non-statutory labor exemption end, and the right to disclaim a union, and we don't have to get into the rehash the details of that. From somehow that case is 15 years old, but what's interesting about that time period, and I'm curious because I know you've represented clients who sometimes you made conflicting arguments for one client and then for another client, but in that case, what was notable is that you were representing the league, and on the other side was Jeffrey Kessler, one of the most well-known players side antitrust lawyers in the country. And then the NBA at the same time was going through a similar issue. And you ended up teaming up with Jeffrey Kessler to take the Players Association side versus the league. So tell me a little bit about why you were on the NFL side for one case and then a matter of months later on the NBA players side in a similar case. Different facts because of the timing of the lockout and the disclaimer of the interest of the union. But tell me how you go from representing the league on one side to then joining with your adversary in the next case.
Sure. Well, with respect to the NFL, the issue there was whether the NFL, in a situation where you had collective bargaining, you still had a union, whether the owners of the teams or the teams themselves could in effect use a collective bargaining tool to lock out and under those circumstances, we thought the law was very clear, and the courts agreed with us that the labor exemption to the antitrust laws applied. The NBA situation was different. In the NBA situation, the union in effect dissolved. And once the union had dissolved, there's no longer a collective bargaining exemption. And what you had in that situation is you had the NBA owners engaging in concerted action that was not protected by the labor exemption.
Because they had dissolved their union already.
Because they dissolved the union. And one of the things that people don't always understand is that there is a labor exemption to the antitrust laws that allows for collective action, both on the player's part and on the employer's part. And when you have a group of employers and a group of unions bargaining with each other, they can have a concerted action that does not violate the antitrust laws.
Right.
However, if there is no union, so there's not a collective bargaining situation, then the antitrust laws apply. There's no labor exemption.
Right.
So in the one hand, you had collective bargaining, you had a union, and hence you had a antitrust exemption. In the other case, the union that dissolves, you did not. And just as a footnote, one of the things that is just under the surface in terms of the Fanatics Panini controversy is the American Needle issue. And that,
right.
and that is whether the Players Association, for example, can engage in concerted action in a non-union context.
Right.
Remember, their collective bargaining is only vis-a-vis the owners. It's not vis-a-vis Panini or Fanatics. So they're not protected by the labor exemption. And one of the issues is going to be whether they have the right to engage in this concerted action, collective action, conspiratorial action, depending on how you want to describe it, with respect to licensing, name, image, and likeness.
So the argument there is that the union itself, when they are organizing and engaged in concerted activity to benefit the members of the union with management, it's protected by the statutory labor exemption and the non-statutory labor exemption.
Yes.
On which part, but if they are negotiating as a collective with a third party, like a Fanatics or a Nike or whoever it might be, then they're not protected under the labor exemption, either the statute, certainly not non-statutory because it's not a collective bargaining relationship.
Right.
But you're also saying it wouldn't be protected under the statutory labor exemption, and so that their agreement to come together and negotiate as one players collective might be illegal. Is that?
Yes, absolutely. And I think American Needle really lays out that framework. The American Legal being a Supreme Court case.
Right. And so, and American Needle is where the league argued that they were a single entity and that their exclusive deals should not be subject to Section 1 scrutiny. But here you're saying the Players Association activity. So does that matter, though, if it's part of the collective bargaining agreement where they agree to license collectively their rights to the league to use it, and then the league then goes and takes those rights to Panini if it's part of the CBA or as opposed to a separate deal?
I think if you had that situation, you would have a real American Needle issue.
Yeah.
Okay. Because I mean, for one thing, any antitrust exemption, it depends on it being essential to the business of the league. And I don't think the licensing of name, image, and likeness of the players probably is. But if you had a situation in which the players had given up these rights to a league like the NBA that has an argument that it is a single enterprise, then you would have a better argument. But that's of course not what happened. The players did not give this right up in collective bargaining to the league. They retained it and have engaged in concerted action themselves. The other thing that I think is significant is when you talk about one team, you're not talking just about a single group of players. in a single league. So again, I think that takes it even further away from anything that could be protected.
Interesting. And so then the I don't know how much you've been following the college sports world and the antitrust issues there, and the question of whether college athletes are employees or certain college athletes are employees or not. And so there's been talk of, even if they're currently not considered employees, and it certainly seems like the NLRB is not going to consider them to be employees, at least until the new administration.
Right.
Got a Fair Labor Standards Act case going on in the Third Circuit. But if there is no union, but the players decide to form an association, a non-unionized association, to then negotiate whether it's a video game deal or a trading card deal. So I guess your argument there would be, if it's a large enough group, then that might be an antitrust violation because there'd be no labor protection because there's no union.
Exactly. In the absence of a union, this is simply concerted action, price fixing, division of markets, things as to which there are per se violations of the antitrust laws. So the mere fact that somebody is a worker, an individual worker, whether it's a player or a lawyer. I mean, we had arguments many years ago that lawyers got together,
Yep.
and the Supreme Court held that was a per se antitrust violation.
Right.
So once you have people, whether they are workers or somebody else, in concerted action, unless you've got some kind of immunity, and there are a few, there's the antitrust immunity for labor. There's an antitrust immunity for state action. I mean, you can have states get together or governmental units get together. But if you've just got ordinary people getting together, whether they are sports players or barbers or lawyers, they're subject to the antitrust laws.
And then it would be interesting if the players were able to make an argument that there are pro-competitive benefits from coming together, but Justice Stevens didn't agree with that argument in the Superior Court Trial Lawyers Association case,
Right.
Which was, I think, the lawyer boycott case you're talking about, or the price fixing case you're talking about.
Yes. Yes.
Yeah, it's really interesting because there's not a lot of conversation about what would happen if the players did come together short of a union. And right now, again, I think another interesting part, and ties back to the NFL case, the Brady case, and the Carmelo Anthony, the NBA case, is whether the college athletes are better off without a union because they have access to antitrust law. And that so far has been a pretty successful weapon. And maybe if they unionize, they wouldn't be a particularly strong union. And whenever management, in this case, the athletic departments, are asking for their athletes, their workers, to be in a union, that sends a signal that maybe the athletes don't want to be in a union.
Yeah, I think the athletes are doing pretty well right now.
Yeah.
And now it's true that the athletes that are doing really well are the very elite athletes. And the one thing that a union does, I think, is protects the less elite athletes. And I think that one of the things that has happened as sort of quote competition, close quote, for college players has really opened up is that the really elite people are doing very well, but we still have a tremendous number of young athletes in school that don't have the kind of protection.
Right.
I think the way that the law has developed here has not actually been all that desirable, because I think that what you had was the NCAA for a long time just prohibited everything, and then they just opened the floodgates.
Right.
And there really was not a consideration for the vast majority of student athletes that are not going to get these multi-million-dollar NIL contracts. So I think that there's still a lot that can be done by the universities to make it a fair situation.
And speaking of, let me ask you a very unfair question. Justice Kavanaugh wrote a scathing concurrence in the Alston case, 9-0 decision. If anything can bring this country together, apparently it was the dislike for the NCAA or the NCAA's old rules. And what if that antitrust case got to the Supreme Court where it's just challenging the whole system, saying that you shouldn't be able to restrict any form of compensation. And if Georgia Tech wants to pay $1 million to the athlete, and then Georgia wants to pay 10 million, that they should be able to decide that, and competition will give us the best outcome, not rules from this national organization. The NCAA argues, but we're different, we're special, just like every antitrust defendant has ever argued. What do you think the outcome would be in this Supreme Court? These 9 justices had to decide whether the basic system of college sports, again, absent a union, absent collective bargaining, they had to decide whether it violates antitrust law or not.
I think the justices would hold that the old system clearly violates the antitrust laws. Now, I think the universities have been very uncreative in adapting to a new world in which they're not going to be able to stiff the athletes entirely. I mean, for example, if the universities all got together and agreed that they would provide certain basic protections for athletes, particularly in contact sports, long-term medical care and monitoring, the ability to finish college later, counseling to help people adapt if they're getting money or if they're not getting money. I think that the universities could agree to provide all of those things to everybody. Now, that would reduce the amount of money available for the open bidding.
Right.
But I think the Supreme Court would clearly allow that. And that would be a way of diverting some of these large amounts of money that are being collected and paid out to protect a broader group of people than just the really elite athletes. And I would hope that the universities would have the creativity and have the concern for the many student athletes that are not going to be highly paid and not going to be the subject of bidding wars.
And do you think that would pass muster because it helps create this different product, or just because it helps a broader, like, why would that be legal when normally we would just say let competition determine who gets what and who pays what?
Because I think in general, efforts to provide a broad base of welfare for groups of employees have been sustained. I think programs to provide retraining and education, things that are broadly distributed, have generally been restrained. Now, you can argue that any money that goes there maybe reduces somewhat the amount of money that's going to be for the bidding for the very elite athletes.
Right.
But that's never been really a fundamental antitrust problem.
Right. Right.
So I think the universities have more flexibility to develop a fairer system than they're doing.
And then last 2 quick questions, because I kept you longer than I told you I would.
No,
but
that's okay.
One of the issues that really went unaddressed in the Alston case, because the parties didn't contest it, but was whether cross-market balancing is permitted or not. And so the NCAA for decades has said that they can restrict player compensation, mobility, put all these rules in because it makes a better product. And we've seen in other cases where the courts have said, no, you can only compare competitive effects in the relevant market. So if it's a labor market case, which is what the players are arguing, then you don't get to offset harms in the labor market to benefits in the product market. And in Alston, so we had the American Express case, we've had cases that have addressed this in different contexts. Supreme Court didn't decide it in Alston. House was settled. There are some other cases coming up. Do you think we'll get a unified answer there, or do you think that college sports just may continue to be treated differently, where they are willing to offset harms to the athletes as long as it's creating this product that not only maybe helps the broader set of athletes, but helps the consumer?
Well, I think you have in the two-sided market cases, you mentioned American Express. I think you have in the two-sided market cases a willingness of the courts to look at in rule of reason cases,
Yep.
the offsetting effects in related markets. Now, whether you will have the same openness in what have been traditionally viewed as per se cases, I think is a different question. My expectation is that you will, because my expectation is that other than sort of pure commercial price fixing cases, group boycotts, market division, the court wants to look at what the economic effects of transactions are going to be in the economy. And so I think that you will see a greater willingness of the courts to consider all of the effects of the conduct, not merely fragmenting it market by market.
Right. Right. Yeah, and that's certainly been the way they've handled it for college sports.
Right.
All right. Last substantive question, because I think this also relates to the battles we're seeing in college sports, more from the university on the conference side, but you represented New York Yankees when they were suing Major League Baseball,
Right.
and we don't have to go through the whole story of how that impacted your legal career and where you ended up practicing, but that was sort of related to the Cowboys suing the NFL. And really both arguments were, and I'm simplifying it, is that the Yankees wanted to do a deal with Adidas. The Cowboys wanted to do a deal that could generate more money, and they didn't want to have to share all of it with their 31 other owners. And so there is this tension where the value in the league comes from having all of these teams, but there's also value in an individual team. And so whether it's the Yankees or the Cowboys or it's Ohio State, there's going to be this tension between, yes, we are worth more because we have these competitors that we don't want to drive out of business, like in normal industries, but we also want to be able to capture more of the value that we are creating. So can you talk a little bit about just that Yankees case, and it was eventually settled, but the broad argument that the Yankees made and how you see that maybe fitting in with the landscape ahead of us?
Sure. And of course, the Yankees case was complicated by the fact that baseball
Right.
is the only sport that
Right.
has a antitrust exemption.
Right.
100 years ago, the Supreme Court decided that baseball was not a business; it was a sport, and so the antitrust laws didn't apply. Now, they quickly figured out that that didn't make any sense; that these were really big businesses, and so when the NFL and the NBA and other sports came along, they decided that they didn't get that exemption. But because they'd given Major League Baseball that exemption, they've kept it. So Major League Baseball has a special exemption. Now,
which led to one of my favorite Supreme Court quotes of all time. I'm going to paraphrase it, but it was in the Kurt Flood case where
yeah,
they were explaining why they were maintaining the baseball exemption while not giving it to any of these other leagues that were exactly the same, other than the shape of the ball and
right.
maybe the surface they played on. They said there may be illogic and inconsistency, but beneath that is a layer of consistency.
Right.
I just love the idea of being consistently inconsistent.
Justice Holmes once said, "The law is history, not logic."
Right.
And so in Major League Baseball, what we had to argue was that this had to do with sponsorship, the Adidas sponsorship.
Right.
That those sponsorships were not part of the business of baseball.
Right.
That the business of baseball might have an exemption, but sponsorships didn't. And that would be even more true for sports that do not have a baseball exemption. So I think that the analysis you have to look at, is this something that is essential to a league? Is this something that's essential to having a multi-team league or not? And I think that when you're dealing with trademarks, you're dealing with apparel, you're dealing with sponsorships, the answer is that it's not essential to having a league. There are lots of ways to preserve a competitive balance. A draft is one. Luxury taxes are another. You may very well have a luxury tax that diverts some of the money that is being acquired and spent to other teams. But what you don't want to do is prevent the teams from competing with each other.
Right.
But what you don't want to do is, for example, limit the number of suppliers who can sell a Yankees hat. That just restricts competition in a way that is not essential to having a baseball league.
And all right, this I promise is the last substantive
It's
question.
okay.
So going back to college sports, one argument I've made or suggested is that with all these restrictions on athlete compensation, the NCAA arguing they need it for cost controls, which is not a very good argument to lead with, as you know, on the antitrust grounds, but also arguing that it differentiates it from pro sports and that allows them to focus on education because it is part of the university and higher education. But the question is, well, why? And Justice Thomas asked this during the Alston oral arguments. Why aren't you limiting coaching salaries? Why are you
Exactly.
spending 12? So the NCAA's argument response to that has always been, well, we tried and we lost that antitrust case. And I don't know if you remember that. That was when they took the lowest earning coach on a basketball staff and said, we're restricting your salary. And it was just a terrible case to bring from an antitrust perspective. And it was just one case in I believe it was the 10th Circuit. But if they said, rather than going less restrictive, if they actually went more restrictive and said, we're not only going to put a limit on how much the players get paid, we're just going to give an overall athletic budget cap that includes coaches, facilities, administrators, and athletes, because the only way we can maintain this unique product is if we truly spend on, as you said, all of the athletes and all of their health care and maintain a focus on education. But if we limit how much we pay athletes to $20.5 million a year and yet pay the coach $70 million to not coach because we fired him without cause, then are they really doing anything? So in a way, having a broader restriction might be more pro-competitive and might be more justifiable. What do you think about that? Or are they just opening themselves up to lawsuits from more potential plaintiffs because now you're restricting compensation for more people, not just athletes?
I think that if you'd had something that looked a little fairer,
Yeah.
I mean, the idea that the athletes that are out there on the field getting concussions, being diverted from their education, were going to not get anything or anything significant, and the coaches were going to get hundreds of thousands or millions of dollars.
Yeah.
I think that just struck people as being unfair.
Yeah.
So I think a more restrictive approach, might have worked. I think that probably it would have had to be coupled with something that provided real financial benefits
Right.
to the players. I mentioned before things like long-term health care and monitoring, educational assistance, counseling, the kinds of things that we know that the college players needed. And I think that if you had had that money being spent that way, I think that might have headed off the sort of the opening of the floodgates.
Yeah. And now the floodgates are open. And it is interesting to think if there had been a luxury tax on coaching salaries, that if you pay over X amount, then 50% of that goes to athlete benefits.
Exactly.
And
Exactly.
yeah, yeah. All right. Well, thank you. So you've been incredibly generous with your time. I do want to now this is not a substantive question, but I know, and you've talked a lot about this, that you overcame dyslexia as a child and learned to compensate with obviously some other incredible skills. My son has learning differences a little bit more significant than yours were, but what's your piece of advice, your wisdom to whether it's a person dealing with learning differences or a parent to maybe not become David Boies, maybe to be like the 101st most influential person in the world. But what's your general advice to people listening?
I think the most important thing is patience and a recognition that the differences that seem extreme when you are in middle school and even high school
Yeah.
Are going to diminish over time. Nobody cares when you get out of school how fast you read. I still read slowly. The things that make a difference when you get out in the quote real world close quote is your character, your work ethic, your integrity, your creativity. And a lot of people with learning differences have great creativity. So that the things that really matter when you get through the tunnel are things that are much more important than the learning differences that you have. The problem is that is awfully hard to accept when you are a 10th grader who or 10-year-old who can't read. And it's very hard for parents to go through it. I was actually very lucky in the sense that when I grew up in a small rural farming community in northern Illinois in the 1940s, nobody much cared whether I read much at that point. Neither the adults around me or certainly my classmates. It was much harder. I have two sons who are also dyslexic. Much harder for them growing up in urban environments where reading skills get correlated with intelligence. I think patience and just understanding that what seems so critical to you right now isn't going to be that important. Really, just 10 years later.
Well, thank you. That is great advice. And again, I can't thank you enough for your time
Thank you.
today, but more importantly for all that you've done for the legal community, for this country, whether you're icon, legend, grandfather, all of the above. Thank you for being a model for what a great lawyer can be and should be, just the way you act in and out of the courtroom and your values and what you brought to the legal profession and inspired so many of us and continue to inspire so many of us to be good lawyers and to be good people. And so thank you for everything. And again, thank you for your time here.
Thank you very much. It was great, great to talk to you.
And when we get the summary judgment stage, maybe I'll have you back on.
Yeah, absolutely.
All right. Thank you so much. Happy holidays. Happy New Year.
Happy
I really
holidays.
appreciate the time.
Take care.
You too. And thank you for listening. And thanks as always to my loyal sponsor, the Tulane Center for Sport. See you next time on Sports Wise.